Good morning or afternoon, depending on where you're joining us from today. My name is Kim Wilcoxon. I'm a partner in the Thompson Hine Employee Benefits and Executive Compensation Practice. I'd like to welcome you to today's webinar. I'm delighted to introduce three other colleagues that will be presenting today. Dominic DeMattis, a partner in our Employee Benefits Group. From our Labor and Employment Practice, we're joined by partner Debbie Brenneman and associate Sarah Hamilton. From now until 1 o'clock, we'll be discussing some of the key provisions of the CARES Act. Please feel free to use the question box located in the control panel to the right side of your screen to submit questions. Due to the large audience we have on this call, we ask that you keep your questions general in nature and limited to the areas we're discussing today. We'll answer as many of the questions as we can at the end of the webinar, and we'll continue to remain online until 1:15. The webinar is being recorded, and we'll send a link to all attendees within 48 hours of today's presentation. Thank you for your interest. And now I'd like to ask Debbie Brenneman to begin the webinar.
Thank you, Kim. It's a pleasure to be with you all again. I want to start by giving a brief overview both of the developments pertaining to employers in the CARES Act and also an update on some of the guidance that's been coming out from the Department of Labor under the Families First Act. So we'll talk about both of those. Let's start first with an overview of some provisions of the new CARES Act. Next slide, please. The CARES Act first does a couple of cleanup things. It amends the Families First Act in a couple of ways. It fixes some math that was set forth in the original act and clarifies that for individuals who are receiving benefits under the Extended Family Medical Leave Act, those benefits are capped at $200 per day or $10,000 in the aggregate. It also clarifies that for individuals receiving paid sick leave, those caps are either $511 per day for full-time employees in certain circumstances or $5,110 in the aggregate. And for other categories of leave who receive 2/3 pay, those are capped at $200 per day or $2,000 in the aggregate. The CARES Act also expands the definition of an eligible employee under the Expanded Family Medical Leave Act. And what it does is say, if you have laid off an employee previously, and this goes back to March 1st, if you laid off someone from March 1st and they are then rehired, they are not entitled to benefits while they're laid off, but if they do become rehired, they still are eligible to take those benefits. The 30-day calculation won't be impacted by the fact that they were laid off for a period of time. So they're laid off, they're rehired, they then become eligible for benefits under the Expanded Family Medical Leave Act. Next slide. Another important component for employers and employees is the unemployment insurance component of the CARES Act. It does a few things. First, it extends benefits to workers who are traditionally not eligible for unemployment benefits, gig workers, independent contractors, self-employed individuals, extends coverage to those individuals. And what it does is for eligible employees, it pays an extra $600 per week on top of the state's benefits. That amount is not based upon income. It is not a sliding scale like the state benefits. It is an extra $600 per week. So many employees who are now eligible for unemployment might be making more than they were during the time that they were employed. And the government recognizes that, but it is a flat $600 per week. It also provides a 13-week extension so that maximum benefits in most states would be 39 weeks. So expanded coverage, this is an opt-in program for states. They do need to apply to the federal government, and the federal government will be funding it. We are still waiting to see updates on Ohio's unemployment website with regard to this, and clearly all states are in the process still of linking in and joining this program. Next slide. I want to spend a few moments now, and just so you know, in a few moments, Sarah Hamilton will be addressing other components of the CARES Act having to do with some of the loan provisions for employers. So we will address that in a few moments. But I also want to spend some time talking about the DOL guidance for the Families First Act. About a week and a half ago, the Department of Labor began issuing some questions and answers, and they have been regularly updated. They started with about 14 question and answer scenarios, and it's expanded to 59 as of today. It's answering some questions, but it's also creating some confusion because on a regular basis, the Department of Labor is actually changing some of its prior guidance that it had already put out there in this question and answer. So we've been checking it on a daily basis to see how it changes and evolves over the course of time. So some of the important guidance that we have obtained, let's go to the next slide. First is the calculation of employees on whether you determine whether you have more than 500 employees and therefore are not subject to the Families First Act, or if you have fewer than 500 employees and are obligated to provide the leave outlined in the Families First Act. So the original guidance had a confusing formula where 2 tests were used for the Paid Sick Leave Act, and then another test was used also for the Expanded Family Medical Leave Act, and it left us all scratching our heads. Now it's been clarified, but still both tests are used in determining whether you have more than 500 employees or fewer than 500 employees. But both of those tests apply to both the Paid Sick Leave Act and the Expanded Family Medical Leave Act. So when making that calculation, as you're doing so, you look at the integrated employer test, which looks at the interrelation of operations, common management like common directors and boards, centralized control of labor relations, and common ownership. If you meet that test and that puts you over 500 employees, neither of the leave provisions apply to you. You also look at the joint employer test, and that joint employer test looks at control of the employee, hiring and firing, supervision and control of the employee's work schedule and conditions of employment, who determines the employee's rate and method of pay, and who maintains the employee's employment records, those sorts of factors. If you have a joint employment situation and that puts you over the 500 employee threshold, then again, you are not subject to the provisions set forth in the Families First Act. Next slide. There's also been some clarification on how the Paid Sick Leave Act and the Expanded Family Medical Leave Act work together. There was a lot of confusion about whether an employee who is eligible based upon the fact that there's a school, daycare, or childcare issue, that's, again, the only reason that someone gets the Expanded Family Medical Leave provisions. But there was some confusion whether that type of individual would first get 2 weeks of paid leave and then 12 weeks under the Expanded Family Medical Leave Act. The guidance says no, only 12 weeks total. So the employee may be eligible for both leaves, but they would first take the 2 weeks paid. That would take care of the first 2 weeks under the Expanded Family Medical Leave Act, and then the remaining 10 weeks would be paid under the Expanded FMLA. So it is only 12 weeks total, not 12 weeks plus 2, 12 weeks total. Next slide, please. There's also been some changing information about documentation and record keeping. We do have, and again, this is another one that has been changing a little bit by the DOL as the days have ticked by. But the Department of Labor is now saying that if you intend to claim a tax credit under the Families First Act for your payment of sick leave or the Expanded FMLA, you should retain appropriate documentation in your records. Now, unfortunately, the DOL does not go on to explain what exactly is appropriate documentation. It does reference that you should check with the IRS regarding applicable forms, instructions, and any information that they might provide. I have not yet seen any specific guidance from the IRS as to that documentation either. But it is interesting to note that the Department of Labor does also say that if you are, as an employer, do not receive sufficient materials to support the applicable tax credit, then you are not required to provide the leave. I will say I think this is a dangerous line to walk because, of course, the DOL and every other agency is expecting employers to be flexible with regard to the, to these policies. So I think that that is something, if you are in that situation, certainly consult counsel before you determine not to provide the leave because of a lack of documentation. Next slide. talk about intermittent leave. The original thought was that intermittent leave would not be available under the Expanded Family Medical Leave Act because it didn't reference the intermittent leave provision in the original FMLA. But now the DOL has issued a guidance saying that intermittent leave may be taken under both acts, but it pertains only to the Paid Sick Leave Act for the child care, school closure, child care provider situation. So it basically has the Paid Sick Leave Act mirroring the Expanded Family Medical Leave Act with regard to the intermittent leave provision, and importantly is only if the employer agrees. So for instance, if the employee says, hey, I've got daycare or child care covered Monday, Tuesday, Wednesday, but I need leave on Thursdays and Fridays, that might be a scenario that would be particularly relevant for intermittent leave. And it is also worth noting that the DOL guidance expressly encourages employers and employees to collaborate to achieve flexibility and meet mutual goals. And again, reminding that if an employee can telework, then they would not be eligible for paid leave under these acts. Next slide, please. Another important clarification from the Department of Labor is that leave is not available under the Families First Act if your work site has been closed, if it's been closed temporarily, or if the employee has been furloughed or laid off. Originally, I think many employers and many experts were anticipating that if you crossed the April 1st threshold and the individual still was at your workplace, if you later laid them off, they would still be entitled to this leave. Not so according to the guidance, although if that employee comes back to work or the site is reopened, then the employee would be entitled to leave if there's a qualifying situation. Next slide, please. The guidance also discusses the impact on FMLA for other purposes, and I think this is an important clarification. So again, the Expanded Family Medical Leave Act is only pertinent to employers who have fewer than 500 employees and pertains to employees who have been there for 30 days. There are different scenarios for traditional FMLA. So there are many employers who are being subject to Family Medical Leave Act type provisions for the first time. But this guidance really discusses how this works for employers and employees who are eligible for FMLA outside of the Expanded Leave Act. So first of all, with regard to paid sick leave, an eligible employee who triggers one of those provisions of the paid sick leave is entitled to paid sick leave no matter how much FMLA he or she has already taken. So if that employee has already maxed out, taken their 12 weeks, they're still entitled to that 80 hours of paid sick leave under the Paid Sick Leave Act. But with regard to FMLA, for those employees, the time they've already taken will determine how much expanded FMLA they now get. So if they've already taken 4 weeks under FMLA for other reasons, then their Expanded Family Medical Leave Act availability will only be the remaining 8 weeks. Similarly, if they take any Expanded Family Medical Leave Act now, that will be counted later if they have any other FMLA qualifying events. So they still only get 12 weeks total. And I think that's an important clarification for employers. Next slide, please. The other thing that we were all anxiously awaiting is some type of guideline for the small business exemptions of some applications of the Act. We knew that they would apply to fewer than 50 employees, but the original Act said that there would be guidance with regard to how to obtain that exemption. Well, this long-awaited guidance basically says you self-designate. Next slide, please. Under the guidance, a small business may exempt itself if an authorized officer of the business has determined that the provision of paid sick leave or expanded FMLA would result in the small business's expenses and financial obligations exceeding its available revenues and cause the small business to cease operating at a minimal capacity, or the absence of the employee or employees asking for the leave would entail a substantial risk to the financial health or operational capabilities of the business because of their specialized skills, their knowledge base, or their responsibilities for the business. Or there are not sufficient workers who are able, willing, and qualified and who will be available at the time and place needed to perform the labor or services provided by the employee or employees requesting the type of leave. So if you, as an authorized officer of the business, make that determination and you have fewer than 50 employees, then you are entitled to an exemption from the leave provisions of these acts. And with that, I will turn it over for the moment to Sarah.
Good afternoon, everyone. My name is Sarah Hamilton. I'm in the Atlanta office on the employment team. I'm going to be talking about the Payroll Protection Program, which is also known as the SBA loans, or sometimes called the Section 7A loans. So, brief overview. I'm going to very quickly go over the technical requirements. There's a lot of stuff to cover, so I'm not going to talk about every point on the slides. I'm just going to go over the technical requirements and then hopefully have enough time at the end to talk about some of the strategic considerations for employers. Next slide. So very high level overview. This Section 7A loan program was part of the stimulus bill passed last Friday. So this is a loan program where the government's making $349 billion of loans available. And loans is kind of used loosely because even though it's structured as a loan, if you use the loan in a certain way under certain conditions, you can get some or all of the loan forgiven by the government. So very important note though, you cannot use this type of loan and get the payroll tax credits, which were in a separate provision of the stimulus bill. You have to get one or the other. You can't get both. So, however, if you have gotten an SBA disaster loan, also known as the EIDL loan, you are eligible for a Section 7A loan as long as you're obtaining it for a purpose or a cost that wasn't included in your SBA disaster loan. Next slide. So the main feature of this loan program is very favorable provision. So in the usual SBA program, you have to make certain certifications like you can't get credit, you have to personally guarantee it. For this specific program, they're waiving all those requirements and they're also allowing complete deferral of payments for a minimum of 6 months up to 12 months, forgiving prepayment penalties, and the amounts that are forgiven are not taxable as gross income, and the amounts that are not forgiven have very good payback terms, a maximum of 4% interest, but the SBA recently came out and said it's actually going to be less than 1% interest for those payback terms. Next slide. So I know what you guys are thinking, this is so good, let's borrow 10 years of business expenses. Unfortunately not, you can't do that. There's a maximum amount that you can borrow under this program. For most businesses, it's going to be 2.5 times the average monthly payroll costs that you incurred in the last year. So you should look at your payroll costs incurred in the last 12 months, divide that by 12, and multiply that amount by 2.5. Plus, you can add in any SBA disaster loan balance that you have, and you can put that in this loan as a refinance and do that together. Now, if you were not in business last year and can't calculate your payroll, then you can use your average monthly payroll from January and February of this year, again, multiplying it by 2.5. And in either case, it's going to be a $10 million maximum borrowing amount. Next slide. So payroll costs I put on a separate slide here because it has a very broad definition. It's broader than what you might think it is. It's not just the amount that you're paying the employees for the salary or their wages. It also includes things like the state and local taxes, any kind of employer contributions for healthcare plans, any kind of severance payments that have been made in this look-back period, usually going to be the 12 months. But very important note, it's going to be a maximum of $100,000 per employee when you're calculating the payroll cost in that 12-month period. So if you have an employee, for example, that earns $95,000 and maybe with all these other kind of add-ons, it goes over 100, you're capped at 100, or if an employee earns over 100, you can't go past that amount when you're calculating the 2.5 times payroll costs. Next slide. So who is eligible for this type of loan? So first, if you're already a recognized small business by the SBA, you're covered by this. But this loan program has expanded it to basically include any small business with less than 500 employees. They've also added nonprofits and self-employed individuals, but I'm mostly going to talk about small businesses today under this expanded definition. Next slide. So what is a small business? First, there's no requirement that it be a certain type of legal entity. It can be a LLP, LLC, anything like that. The most important thing is that it have less than 500 employees in this kind of specific date from February 15th of this year, including employees of all the affiliates. So in the statute, the word employee refers to full-time and part-time employees. It also uses the word other, employed on other bases. And I think we have to wait for the regulations to come out, but we don't think this word means your independent contractors. It's probably referring to things like your temporary employees or your interns and things like that. Now, affiliate is a very technical term in the SBA, so could be its own presentation, but very, very generally, if there's common ownership, if you have like an equity fund that controls a lot of companies or a common person who owns a lot of different types of companies, all of those companies together should be considered as affiliates when determining whether you have 500 or less employees. Next slide. There are some exceptions, though, to these affiliation rules that were made just for this program. So if you are a business with a North American industry code beginning with 72, you can ignore your affiliates for counting your employees when you're trying to qualify for this program. So, for example, if someone owns 10 different companies and just one of those companies is a restaurant, a bar, or a hotel, which is the business that begins with 72, then they could qualify for that restaurant for that loan, even if altogether all their companies have over 500 employees. So keep that in mind. Next slide. So there's also another way to qualify by location, and this is going to be limited only to, again, businesses that have a North American industry code beginning with 72. We're talking about hotels, restaurants, and bars. So let's say you have a chain of hotels or a chain of restaurants, and altogether there's way more than 500 employees. But if there's one physical location that has less than 500 employees, then that business could qualify for this type of loan if it's in this industry code. Next slide. So what can you get what can you use the loan amounts for? So first, you have to use the loan amounts in a certain time period. That's until June 30th of this year. These are there's 5 things you can use them on, and you can see them here on this list. And I've bolded and put asterisks next to the first 3 bullet points, because these are the types of costs that you can use the loan program on that will be forgiven by the government if you meet the other conditions of the program. And so those conditions are, again, if you use it on these first 3 categories, the obligation must exist prior to February 15th. So no, you can't go out and lease a very expensive office space and be, look, I want the government to pay for it for 8 weeks. It has to, that lease agreement would have had to exist prior to February 15th. For the forgiveness amount, it has to be used within the 8 weeks of the loan origination. So once you get the loan origination date, you should calculate that 8 weeks, because it's going to be a very important date. And finally, the maximum amount of forgiveness can be reduced by certain limitations, 2 limitations which we're going to discuss today. Next slide. So the first limitation is if you reduce your full-time equivalent. So go ahead and there's some more parts of the slide if you keep pressing enter, Kim. Okay, there we go. So this is a calculation in the statute that you basically look at your full-time equivalents. This is not your head count. This is the number of employees you have altogether that are equal full-time employees in that 8-week period. And you can divide it by either the number of full-time equivalents you had in the same period in 2019, or the number of full-time equivalents you had in January or February of this year. You get to choose which denominator you want. So let's go over an example really quickly. Next slide. Let's say I have a business, I get a loan today. So in the 8-week period, in the first month, I have 1 full-time employee, and in the second month, I have 1 full-time employee with 2 part-time employees. My average, again, we're going to look at the average full-time equivalents, not the headcount, would be 1.5. So that'd be the numerator. Keep clicking through, Kim. And then for the denominator, we could, again, choose one of the methods. And this one, we'll say we'll look back to 2019. And let's say in that period, I had 2 part-time employees and 1 full-time. My full-time equivalents would be 2. So basically, we would divide these two numbers and we would get a multiplier of 0.75. So if I were looking at all the loan amount that would be eligible for forgiveness because I spent it in those 3 categories in the first 8 weeks, I'd multiply it by this number, which would basically, in this case, reduce the amount that could be forgiven, which reflects the fact that I have less full-time equivalents in this time period. Once again, the purpose of this loan program is to keep people on payroll. Okay, the second limitation we're going to talk about is a little bit more complicated, but basically there's a dollar-for-dollar reduction from the forgiveness amount if you reduce people's pay over 25%. So as an example, in this 8-week period when you have people on payroll, if you reduce it over 25% compared to what they earned in the last quarter, that will reduce the forgiveness amount. And very important note, this does not apply at all to employees who earned over $100,000 in any single pay period on an annual basis in 2019. So this one's not a quarterly calculation, it's going to be a pay period calculation for your exclusion of highly compensated employees. So next slide, we'll go over an example here. So let's say in Q1, I had 3 employees, one made $150,000 and 2 made $50,000. And for this 8-week period that I get this loan, I want to reduce everyone's salary to 100 and then the other people to 25. How would that affect the forgiveness amount? Well, first of all, the employee who earned over $100,000, that reduction wouldn't penalize me at all because he earned over $100,000. But the other 2 employees was a reduction of 50%. So we would take the amount over 25%, which is another 25%, which is about $12,500 annualized. And the amount of salary paid in that 8-week period that was less would be deducted from the forgiveness amount. So in this case, if you do the math out, in that 8-week period, I paid these people about $1,900 less each. So my forgiveness amount would be reduced by $3,800 or $3,846.15. So next slide. Now there is there are some exceptions for these 2 rules. So if you have a reduction in full-time equivalents in this certain time period as compared to February 15th, or if you have a reduction in payroll during this period as compared to February 15th, and you correct it by June 30th, then you won't be penalized by either of these rules. Once again, this is an incentive by Congress to rehire and keep people on payroll. So, one question people might ask is, what if I've already laid off employees or they're already on payroll and I have no work for them to do? Well, the Act, as it currently reads, there's no prohibition in the Act right now that they actually have to be performing any work. The limitations are mostly just looking at your full-time equivalents plus your payroll amount. So next slide. So some different issues with being strategic. So the first point if you're going to apply for this type of loan is I would simply recommend that people do the math. These are kind of technical rules that each have their own kind of periods and ways to calculate them, and there's different choices that can be made by the employer. So understanding the rules is going to be really important to this. Full-time equivalents, once again, when you look at the denominator, that's the bottom number of the fraction, you get a choice of how you want to calculate that number. You should definitely choose the lowest one. It will be the most favorable to you. And then the full-time equivalent, the numerator of that fraction that's going to be in the 8-week period, that's going to be a number that is yet to be determined, but you need to look at the 8-week period from the loan origination. So this is not the date that you apply for the loan or that you're approved for the loan. It's the date that it's originated, and you should probably look at that 8-week period and say, what do I want this top number to be as divided by the denominator? So, say you want the number to be 10, then you can think strategically about, well, do I need to rehire people? Do I need to not lay off people? And also think about what kind of employees do I want those 10 people to be, because the work might be different and you're allowed to get different types of employees or different types of work. One thing to consider is that the full-time equivalent and the payroll rules are separate. They don't act together. So for example, if you have an employee that you let go that earns $100,000, you could rehire 2 employees making $50,000 each. And that way you would increase your full-time equivalent, but you wouldn't hurt your payroll costs or increase your payroll costs. So I guess on the same note, if you have a current employee making $100,000, you could reduce it by some amount and hire another person full-time for that amount of money, and therefore increase your head count without increasing your costs. So that's something to think about. Second point is, really pay attention to what payroll costs mean. In these types of loans, the lenders are going to be incentivized to burn and churn these loans as fast as possible, and they're going to be very busy people. So I wouldn't necessarily rely on the bankers to help employers calculate this payroll cost, which is a very important number to determine the maximum loan amount. So that's something counsel we can certainly assist with. And then the final point is you can borrow 2.5 times the monthly payroll amount. If you leave all the payroll costs the same, that leaves about 1/2 of a month of payroll for the rent, the mortgage interest, and the utilities, which are forgivable amounts. So if your goal as a business is to try to maximize the amount of non-payroll costs that you want to be forgiven and use for your actual business expenses, then some considerations are try to pay the employees using some other method, for example, the tax credits that are available under the Families First Act. You can borrow the money using the payroll costs, but you don't necessarily have to spend it on that. So if you're able to pay some employees using these tax credits, and then you'll have more money to use towards your rent, which will be forgiven. Another consideration, which isn't super popular, is obviously the rules let you reduce it up to a certain amount and then reduce it even more for other employees. So if you were to use that payroll cost to qualify for the loan and then use that money for rent or something else, you could get more qualification or loan forgiveness for those other categories. Finally, a lot of people have talked about unemployment and whether we should, you can use that to pay the employees. That's not going to probably be as much as if you kept them on payroll, but with all the stuff changing right now, it's certainly something to consider. But that would hurt your full-time equivalent calculation in this. So next slide. I know I'm going through this really fast. We'll be available for questions, but to the extent you guys or any of the businesses are doing anything to kind of qualify for the maximum forgiveness, don't forget that the usual employment laws and labor laws, if you have unions, still apply. So you should be non-discriminatory in how you make pay decisions or rehiring decisions. Some states have notices that you have to give to people before you change their basis of pay or their amount of pay. If you have employees that you're keeping on payroll, but they're not required to work, you still need to have some basis for them to report their hours to pay them if they're non-exempt. And especially for your non-exempt employees as well, if you're making any changes in the pay, make sure it's not done on a basis of days worked. It should be another type of qualification so you don't lose the exemption. Next slide. Some quick notes. The loans open on April 3rd, which is day after tomorrow. To get the loan, you need to go to a lender that's qualified by the SBA already, which is most major banks and credit unions. The SBA is authorized to expand its usual list of lenders. So if you want to keep up on this, go to sba.gov. The SBA has come out and already said this is going to be likely high subscription. I think everyone knew that was going to be the case. It's a first come, first served basis until the money's gone. So even though applications aren't open right now, I would go ahead and get all of your documents together and just be ready to submit, get your banker in line so that you can get that loan going as soon as it opens in 2 days. Last slide. And just a note for the 8-week period that qualifies for the loan forgiveness. The statute is very clear saying that they will not forgive the loan unless you provide documentation. So these are the types of documentation that you will be required to submit after you finish the 8 weeks and you want to apply for loan forgiveness. So as you go along during this next 8 weeks, make sure that you're keeping track of all these documents. You have them nice and neat to submit to apply for the loan forgiveness. So I know that was fast. We'll answer questions as available, but I'd like to turn it now over to my colleague, Dominic.
Thanks, Sarah. We're going to talk a little bit now about some employee benefits provisions that are implicated both by CARES Act and also some related provisions. And there we go. First thing is, just to keep in mind, the general theme here of all of this stuff is, there are provisions that are in place to help employees. There are provisions in place to help business. We're going to talk about both of those from the perspective of, employee benefits. Kim, after me, will be talking about some issues related to health and welfare plans, and I'll be talking more about retirement plans. So this first thing is this idea that you can have some additional distributions generally under 401k plans, although they're available under some other plans as well. Really what these are, for those of you who are familiar with it, the concept of a hardship distribution, these things are really hardships without the proof for the 10% penalty. So, you can, and they're supersized, if you will. So distributions can be allowed under a plan up to $100,000. There's relief from the 10% early withdrawal penalty. There is the income inclusion is very favorable for a participant who receives one of these distributions. They get to spread their income inclusion over 3 years. There's no taxpayer can recontribute the amount to, within 3 years of the distribution. So it's basically treated as a rollover contribution if there were a decision to recontribute, and there's some prior guidance regarding how that might work for people. These distributions are not treated as eligible rollover distributions, so that means you don't have to worry about notices, 402F notices, which some of you probably hold dear and love, related to all of the tax rules. And it also means that they're not treated as eligible rollover distributions for wage withholding purposes, which means they're not subject to the mandatory 20% withholding that would normally apply to a distribution from a pension plan. Instead, they are the 10% withholding, which is optional, applies. So a participant could receive one of these distributions, elect no withholding, and not pay the withholding, and then ultimately, if they were to pay it back, not have to worry about taxation. The way the statute is written is these distributions apply to, it applies for starting in January 1st, 2020. There probably were very few people who would have been eligible as of January 1st, 2020. We'll talk about eligibility in a second. But the main reason why this, seems kind of odd, well, why is there this earlier effective date for these distributions? And the reason, at least my opinion is, the reason is so that it would be permissible for a participant to recharacterize a hardship distribution that they may have already taken, assuming if they're eligible, and they were eligible at the time they took the distribution. There's an explicit exception to the in-service rules, the distributable event rules under 401k. So in other words, you can do this before age 59 and a half. But there is no exception to the general pension plan rules. So for money purchase plans and defined benefit plans, sure, you could have these distributions available under a plan at age 59 and a half or older, but they're not available for folks younger than age 59 and a half. The interesting thing to note about this is that, and I'm characterizing these as distributions under a plan, and that's the way they're presented, and that's the way people think of them. However, it's important to note, and we'll talk about some options that are available under plans later if you don't want to amend your plan to provide for this option. The fact that a plan is not amended to provide for this type of an option does not necessarily mean that a participant might not be able to get these types of tax benefits for one of their distributions. So, that's just something to keep in mind. So now moving on to the next for eligibility, who's eligible here? Well, somebody who's been diagnosed or whose spouse or dependent has been diagnosed, and, that's a pretty clear cut. And then we have this second prong, which is, somebody who experiences adverse financial consequences as a result of the stuff that's listed here, being quarantined, furloughed, laid off, having work hours reduced, unable to work their elective child care, or the closing or reducing hours of their own business. Now, these are pretty tough things for an employer to always be aware of. There might be some obvious situations, where people have been laid off and that there's been some adverse financial consequences. But in general, you may or may not know whether somebody has been diagnosed, and, you may not want to be gathering that type of protected health information, which Kim could certainly speak more to, offline. But, at the end of the day, the Congress decided that they were just going to allow individuals to self-certify. So you don't have to worry about the problem of trying to figure out whether or not somebody's really eligible or not. Instead, the plan administrator can just basically ask the question and rely on the self-certification. So those are the distributions. Turning to the next, we'll talk about the plan loan increases. And here, the basic idea is that, there's going to be bigger loans are available, and there is a forbearance that kicks in. So This increase in the maximum loan limit for new loans made within 180 days of enactment, and if I've calculated and counted on the calendar right, 180 days after March 27th, I think is something around September 23rd. So new loans within those first 180 days are eligible for a, up to a $100,000 loan and up to 100% of the account balance, which is an increase over the normal loan limits, which are $50,000 and 50% of the account balance. So this is optional. There's no requirement that a plan allow this, but it's available. There's also the forbearance that kicks in, and the way it basically works is that any repayments that are due between the date of enactment on a loan, on a new loan, or an existing loan can be delayed for a maximum of 1 year. So anything that's due between the date of enactment and December 31st, 2020 can be delayed for a maximum of 1 year. And that period is disregarded for purposes of determining the maximum loan amount, which is very helpful from the perspective of not having to worry about, exceeding the 5-year limit on plan loans. Subsequent repayments get adjusted. The way that this statutory language is drafted, one could easily look at it and think that it's required. But if the IRS follows its path that it's followed with respect to similar statutory provisions in the past, this will also be optional. That having been said, I think there's a good case to be made for, to the extent that you're able to, working with your record keepers, to letting folks know, hey, if you have an outstanding loan and you're one of these eligible folks, come and tell us you're eligible, because you can delay your loan repayments. It's a relatively painless way to provide a benefit to employees who may be severely affected, really at no cost, with the exception of some administrative dancing that you may need to do. So who's eligible for these loans? Well, it's the same as the folks who are eligible for those coronavirus-related distributions. There is some question regarding whether or not self-certification is permitted here, although, it seems to me that there wouldn't be another way to do it because, again, you're not necessarily going to know. Depending on the circumstances, you're not going to know who people are unless they tell you. So thinking about moving forward on this, thinking about some of the implementation questions here, are these things required or are they permissive? It seems to me permissive, and that would be consistent with prior guidance on similar statutory provisions. Is it all or nothing? Do I have to allow a $100,000 distribution, or could I put in a special coronavirus distribution for $20,000 or $30,000 or 50% of somebody's account balance? I think the answer to that is yes. As something that's permissive, you can do part of or the whole thing. What about, do I need a new safe harbor notice if I allow this type of distribution? That's possible. That's something to keep an eye on. I think it would require a facts and circumstances analysis of what's in your notice and also your plan documents and communications. Can I put in a second loan? Like I've got one loan, I only allow one loan under my plan right now, and I want to allow these higher limits for this limited time period. Can I put in a second loan for that purpose? And I think the answer to that is yes. You need to be very careful in general when you have more than one loan in particular, but even with one loan, you need to be really careful about calculating what the maximum loan amount is and what the permissible amount would be. So if you have one loan outstanding already, there are some rules related to how you calculate the maximum available for that second loan. If it's a coronavirus loan related provision for the second loan, you would just replace the $50,000 and 50% of the account balance with $100,000 and 100% of the account balance, but you still need to go through a little bit of tedious calculation there to make sure that you don't mess up on the maximum loan amount for that second loan. And we talked a little bit about existing loans, whether or not there's a automatic forbearance or, whether it's optional. And again, I think that's optional, but, would strongly consider communicating to people that forbearance is available if they're affected and talk to them about self-certification. One other change in the CARES Act had to do with required minimum distributions. And so on the next slide, we've got some information about that. This is just a temporary waiver of RMDs. There's no required minimum distributions required for the 2020 plan year. And so that applies to anything for this year, the 2020 plan year, or any amount that's required to be paid during 2020 because of a required beginning date that occurs in 2020, which on calendar year plans is today, for the 2019 plan year. So to the extent that a 2019 RMD is required to be paid out today, it could be pushed back. Next slide, talk a little bit about plan amendments. I mean, I think you can take a look at this. I think the bottom line is we have time and we have more urgent things to worry about, but just refer to this at your leisure if you need it. Be careful, though, on this, with respect to consistent administration. So while we do have time to amend our plans, we want to make decisions regarding how we're going to ultimately amend those plans, and we want to administer the plans consistent with how we intend to amend the plans later so that we can rely on that consistent administration to get these deferred plan amendment dates. So now we're going to talk a little bit about some other options that are available to assist employees. And so some of these are things that folks, I just point them out quickly for folks to think about because, you may say, well, either we're not that affected or we just have individuals who are affected or we're having trouble getting this implemented with our record keeper, those coronavirus distributions or loans the way we want to. Are there other things we could look at? And the answer to that is yes. Bottom line, if you've got some folks who are on unpaid leave of absence, there are provisions that allow for pushing out loan repayment, and that's under existing law. So make sure that your policies and procedures allow for that, and that's being communicated to the affected people. Maximum cure periods, where someone may default on a loan, some plans and some plan loan policies provide for a shorter period to kick those folks into default than is permitted under law. So make sure you've maximized that to the extent you want to provide the most relief possible. In other cases, you may have one loan, you may decide, well, gee, could we add a second loan, even if it's not a coronavirus distribution? And that may be helpful for folks. And depending upon how folks, how things are working for the people who were your employees or who still are your employees and who are on temporary leaves, it may be advantageous to allow them to continue to repay loans through ACH, or at least the option to do it when they're not on payroll, on your payroll. Other options available, these in-service distribution options. You can always add in-service distribution at age 59.5 or above. And so to the extent that that may help your population and it's consistent with, how your plan document is drafted, you can modify the plan to do it. You can allow that. And certain sources can be distributed before age 59.5. You can go to rollovers or after-tax distributions, some employer contributions, depending upon certain rules. And again, there's rules around this stuff. Now, as a general matter, if you do that, you may say, well, gee, that means that now folks are stuck with this 10% additional tax. And the answer to that is maybe, because just because you, as a plan sponsor, did not amend your plan to provide for a coronavirus-related distribution under your plan, doesn't mean that an individual is not an affected individual who is eligible for the relief from the 10% penalty tax. And so, those two things may be separate. And so adding these types of options for folks doesn't leave them without the benefits of some of those tax the benefits that we talked about before, the 10% penalty elimination, the spread out of income inclusion over 3 years. Next, we'll talk a little bit about hardship distributions. And again, you've got these hardship distributions. Many of you have it under your plan. There's a safe harbor that was recently added for federally declared disaster areas. There's been a little confusion whether or not that safe harbor is implicated already. The answer is that there's certainly authority for it to have been implicated nationwide, although we don't have guidance that says that yet. However, there are a bunch of states, and it's longer than this list now, with respect to whom federal disasters, or with respect to which federal disaster areas, major disasters have been declared, and with respect to which individual assistance is available. So, for those states, this hardship is already implicated. Other safe harbors apply, and yes, hardships they do require the proof. Remember before I said that coronavirus-related distributions are hardships without the proof or penalty, they do still require the proof, so go through your process. But if you're not adding those coronavirus-related distributions and someone comes in to take a hardship, as an individual, that does not mean that they're necessarily stuck with a 10% penalty. They may be eligible for relief from the 10% penalty, even if what they took from your plan was just simply a hardship. But that would be something they'd have to do on their individual tax returns. There's also the possibility of expanding hardship sources and for certain requirements. Turning now to options to assist in, more as options to assist employees, I guess, but turning away from explicit retirement plan things and going into more kind of nuanced things. Of course, we can always add discretionary contributions, and you may say, well, that's kind of hard to do right now, and for some, obviously, it would be cash prohibitive. But for others who are looking for ways to incentivize employees who now face, themselves working under more extreme conditions, more demanding conditions, and more dangerous conditions, that yes, you can provide additional cash compensation, you can provide additional benefits of certain types, and another thing that one could choose to do is to provide additional discretionary contributions into the 401k. And one reason that might be something to consider if you're in that position to do that is because, remember, these are folks who are working very hard, again, under dangerous conditions, watching their 401k balances shrink. And so if, some discretionary contribution that would go in that would help bolster that balance back up a little bit may be very helpful to your employees if you're in that circumstance where that's an option for you. One other thing that folks can do is there's a neat little provision under the law that allows for qualified disaster relief payments. It's a very tax-efficient way to provide certain types of limited benefits to employees. There's no income tax, but it's deductible. You get targeted relief to people who feel financial pressure. It allows for the payment or reimbursement of reasonable and necessary personal, family, living, or funeral expenses incurred as a result of a qualified disaster. And here, there's no ambiguity. The current national emergency, even if a state has not been declared a major disaster area, is sufficient to trigger this provision. It's important to be careful here. You can't pay for lost wages or paid sick leave, but things that are not otherwise reimbursed by insurance, such as reimbursing or helping folks with childcare if they can get it, if it's available, tutoring expenses for school closing, even in-kind benefits such as hand sanitizers and home disinfectants, could be provided under this type of a program. Things to be careful here, make sure it's a written program. If you do this, that you do want to do it in a written way and you want to have sound and consistent administration. Next, we'll talk about some cash preservation options that are available for employers who, need to do that, which of course I know a lot of employers do. So under the defined contribution 401k plan, plan terms are going to dictate the extent to which employer contributions can be eliminated. So it's very, very important to be looking at plan terms to figure out what can be done. But in many cases, you can reduce or eliminate employer contributions, at least prospectively, and going forward. For safe harbor, contributions can be suspended, but there are rules and conditions to be followed. You have to be careful about that and require taking a look at the safe harbor notice, determining whether some other requirements are satisfied, and then also be careful because when you do that, that gives rise to different non-discrimination requirements that, or additional non-discrimination requirements that would not have applied had the plan continued to be safe harbor. You can also scale back auto-enrollment and auto-escalate. That's essentially a way to scale back the amount of matching contributions that are going into a plan. These things can be temporary, prospective. And, the fact that there's been a delay in the tax deadline to January, or generally a delay in tax deadline to July 15th, 2020, that's for calendar year folks, gives you a delay in the time at which you would make discretionary contributions. And so, if your plan document or, provides for discretionary contributions, for example, a discretionary profit sharing contribution to a 401k plan. And you typically would provide that type of discretionary contribution on a certain month of the year. Say you typically do it in March, but there's no requirement to do it in March. Certainly the decision as to whether or not to make that discretionary contribution could be delayed through the tax deadline without losing your ability to take a tax deduction for 2019. Next, we'll talk about some defined benefit plan issues. Clearly you can freeze defined benefit plan accruals to the extent that there's active accruals. Be very careful. Make sure you meet notice requirements. There's notice requirements related to these types of things, and generally it's a 45-day advance notice. Also be careful, some of these benefits are going to be collectively bargained. You obviously want to use extreme caution in considering what to do with defined benefit plans, accruals, or anything else. And even with defined contribution plans or 401k plans, to the extent that those benefits have been collectively bargained. So be very careful about what the collective bargaining requirements are. Lump sum payments, to the extent the defined benefit plan has seen a drain in assets, folks may want to pull back on lump sums. You got to be careful there because they generally can't be taken away prospectively. There is a provision in CARES Act that allows a plan for the 2020 year to use the 2019 AFTAP, which AFTAP is just the reference to the term that decides whether or not you're going to have benefit restrictions under your defined benefit plan, and benefit restrictions basically allow you to not pay lump sums. It's possible that if you had benefit restrictions in 2019, and no matter how 2020 might have come out, you might want to keep those benefit restrictions in place. So there's an option to do that. The other thing is that for most minimum required contributions, for almost all single employer defined benefit plans, there's a delay in any minimum funding required contribution for 2020, including quarterlies, through January 1st, 2021, and the price of that delay is interest at the plan's effective interest rate. Next, we can talk a little bit about just some things to consider with workforce changes. Folks obviously are furloughing. It's important to be consistent with your treatment of folks who are furloughed. Are you treating them as terminated? Are you treating them as unpaid leave? I think generally most folks would treat them as an unpaid leave, but that affects whether or not somebody's eligible for a distribution, how they're handled for service credit, whether or not they can take new loans. Partial plan terminations cause full vesting. So for the affected individuals, that's generally triggered by a 20% or more turnover rate. And so you want to be careful to see whether or not any actions you take with respect to layoffs or terminating people may implicate that. And also material changes in your population could affect your non-discrimination testing. Reportable events show up under defined benefit plans. The most likely possibility is an active participant reduction. Again, this is triggered by a 20% reduction generally. This is reporting to the PBGC, and this affects defined benefit plans. It's important for this purpose generally that if you have folks on furlough who are coming back, who you intend to come back, you generally would not be counting those as being part of an active participant reduction, but you just want to make sure you take a look and analyze your population appropriately. And then whether or not you have a 4062E event, and basically a 4062E event is when if you end up closing down a facility and you have a workplace reduction of 15%. These reportable events and 4062E events, these only apply with respect to defined benefit plans, although the way you count for 4062E is pretty complicated and it includes people who participate in defined contribution plans. For multi-employer plans, there's some considerations. These are plans with respect to which the people participate based on collective bargaining. In some industries, to the extent some multi-employer plans are going to have some financial difficulty based on a significant reduction in their contribution, so that's something to watch for the future based on how things play out in particular industries, if you're in one of those industries. On its own, something that happens here with respect to significant reduction in a workforce, in particular if it's temporary, is not likely to result in a complete withdrawal or partial withdrawal for folks who would worry about that from a multi-employer plan. But be very careful with the way you're communicating your employee actions to your collectively bargained population. You would need to, analyze going forward partial withdrawals. Could be triggered by a reduction in the requirements to contribute if you have a lower number of employees collectively bargained employees going forward, and depending upon how the recovery goes, it it could affect, there could be a partial termination triggered in the future. And finally, next slide, thinking about other employer considerations, we don't have a lot of information now about what type of relief there will be in certain deadlines, like the Form 5500 filing and other types of deadlines related to employee benefit plans generally. We expect that there is going to be something, an IRS press release, an IRS notice that will tell us that in the near future. But as of right now, we're just kind of waiting for that, which of course, they're busy. So, they've got a lot of other things that people want answers to. And, one thing to keep in mind, treatment of paid leave, to the extent that you're providing paid leave, some of which has been discussed on earlier webinars and some of which I think was discussed earlier today. There are some issues with how that's treated compensation under retirement plans, so you want to pay attention to that. Kim?
Great, thanks, Dominic. I'm going to go fairly quickly through the health plan provisions so that we can get to the questions. The detail on these slides will be available to you following the presentation. You will be able to get a copy of the slides. So just starting off as a reminder that the Families First Act required health plans to cover COVID testing at 100%. The CARES Act expands the types of tests that must be required under the Families First Act. So, and I don't know how this is happening, but it sounds like somebody might be off mute. If you could all put your phones on mute. It includes tests that have not necessarily been approved by the FDA yet. So you can see here there's additional types of tests that must be covered. In addition, the CARES Act explains how much a plan must pay for a COVID-19 test. So if the plan had a negotiated rate in place with the testing provider at the beginning of the public health emergency, which was January 27th, 2020, the plan would pay that negotiated rate. If there is no negotiated rate in place, then the plan is going to pay the provider's published cash price. So providers are required now to publish their cash price for the COVID test on a publicly available website. If the plan is able to do so, they can negotiate a lower price with that provider. The CARES Act also requires accelerated coverage of vaccines. So under the Affordable Care Act, non-grandfathered health plans are required to cover recommended preventive services when provided in network at 100%. And a recommended preventive service is a service that's been recommended by one of these 4 agencies. But once an agency makes a new recommendation, the Affordable Care Act gives us at least a year in order to extend coverage for that particular item or service. Under the CARES Act, if it is a COVID-19 related preventive care service, then it must be covered within 15 business days. So essentially, if we get a COVID-19 vaccine developed and it's recommended by the the Preventive Services Task Force or the Advisory Committee on Immunization Practices, then within 15 days, the health plan has to cover that vaccine at 100% when done in network. Next, the CARES Act addressed the question that we had about telehealth services. So under the high deductible health plan rules, generally an employer or a health plan cannot pay for anything other than preventive care before an individual reaches the deductible. Now, the Families First Act had required us to cover telehealth services that resulted in an order for a COVID-19 diagnostic test. The problem with that is that some telehealth providers couldn't tell the difference between a telehealth visit that resulted in a test and one that didn't. Further, we had employers who wanted to waive cost sharing for telehealth services unrelated to COVID-19 to help with the social distancing effort. The IRS had told us that it was okay to waive cost sharing for treatment and testing for COVID-19, but they hadn't weighed in on whether we could waive cost sharing for telehealth services and still be considered a qualified high deductible health plan. The CARES Act says, yes, indeed, you can waive cost sharing services for, cost sharing requirements for telehealth services and still be a qualified high deductible health plan. But this is a temporary requirement or a temporary relief. It will only apply through the end of 2021. So we'll have to wait and see what happens as we roll into 2022. And last, reimbursable expenses. The CARES Act revokes a provision of the Affordable Care Act, which had prevented HSAs, FSAs, and HRAs from reimbursing over-the-counter drugs without a prescription. Now, I believe almost every plan I have ever seen that was a cafeteria plan that involved a medical flexible spending account had a specific language in the plan that said, you know, we'll reimburse medical care excluding over-the-counter drugs except for insulin. So that provision is most likely in your plan. If you want to now reimburse over-the-counter drugs without a prescription, you'll most likely need to amend your plan to do so. This would be effective for over-the-counter drug purchases on or after January 1, 2020. And then unrelated, the CARES Act also considers menstrual care products now to be medical care. So this is something that most likely would not require an amendment to your plan. If your medical flexible spending account reimburses medical care, it will now reimburse menstrual care products. So that was a quick fly through, but wanted to make sure we got to questions. So I'm going to turn it now to Debbie. Debbie, can you further explain how the sick leave and EFMLA applies when employees can work from home effectively?
Yes, thanks, Kim. There is some guidance under the facts that have been issued by the Department of Labor, but it's not very clear. Actually, what it says is if you are unable to work or telework, if the qualifying reasons prevent you from being able to perform your work under normal circumstances. And it does also say, you can, to adjust that, you also can agree with your employer to work different hours than you normally would. But it essentially leaves it up to the employee or the employer to determine whether the employee is able to telework effectively or whether they are unable to do that work as required by the employer. So unfortunately, not very clear guidance on this one.
Great, thanks, Debbie. I'm going to turn it now to Dominic. Regarding 401k loans, for existing loans taken before the Act, any considerations given for those loans regarding repayment?
Yes, thanks, Kim. So for existing loans that were taken before the Act, the forbearance that I had mentioned is available. So a plan sponsor could either, depends on how the plan is drafted, whether it would need a plan amendment or through policies and procedures, loan policies and procedures, could allow for the delay in repayment for those existing loans from the date of enactment, any payments due from the date of enactment through the end of the year. And then basically you can then re-amortize the remaining part of the loan after that period to account for the period of delay. It's optional, or at least my opinion is it's optional.
Thanks. Sarah, the next one is for you. Regarding the 7A loans, do they have anything to do with how profitable the business is currently? So for example, is this only available if the business is losing money related to COVID?
Yes and no. So when you apply for the loan, you have to certify in good faith that the loan is necessary to support the ongoing operations because of the ongoing economic conditions. It doesn't say because of COVID, it just says because of the economic conditions, and that you must certify that it will only be used for the 5 purposes we discussed. So how they intend to enforce that and how do they really determine whether you've certified this in good faith is, I think, an open question, but hypothetically, technically, yes.
Great. The next question is for me. Is the change to FSAs an optional change? With respect to over-the-counter drugs, yes, it is an optional change. The law simply removes the prohibition. It doesn't require you to allow over-the-counter drugs to be reimbursed from an FSA. For the menstrual care products, that's just sort of an automatic get. As long as your plan is reimbursing medical care, it will reimburse menstrual products. If you don't want to reimburse menstrual products, you would most likely have to amend your plan to exclude that. Next question is for Debbie. With respect to the new leave provisions, what if we have an acquisition with their own EIN that has less than 500 employees? Is eligibility based on number of employees per EIN, or is it the full roll-up to the parent company?
Thanks, Kim. That's going to require a little bit further analysis because it is not dependent upon the EIN. You're going to look at the integrated employer test, I would believe, which is going to look at whether there's 4 factors. First, an interrelation of operations, like are there common offices, common record keeping, shared bank accounts and equipment, those sorts of things. The second factor is whether there's common management, common directors or boards. The third factor is centralized control of labor and relations and personnel, and then that factor of common ownership and financial control. So there's really an analysis of all those factors, none of which is determinative. I should say no single factor of which is determinative, must be evaluated collectively.
Great, thanks. Dominic, to clarify, are the coronavirus distributions optional?
Yes. It's not, a plan is not required to be amended to provide for those distributions.
Great. And then for you again, how will a delay in 401k loan repayments be administered? So if a plan sponsor elects to adopt loan delays, will the participant get to choose whether their loan repayments are delayed or not? Or will all loans be delayed across the board, or does it vary by administrator?
Yeah, I think that's going to come down to a decision related how to administer. I can see where some folks may, because of the optional nature, or at least my interpretation of it being optional, I think that allows for folks to decide, well, gee, I'm going to allow this, but I'm only going to allow it administered a certain way. In other words, we're going to do it one way for everybody, or we're going to allow some optionality in there. So I think the answer is it depends, and it may require some modifications to policies, procedures to get to the desired result.
All right, Sarah, this one's for you. With respect to FTE, what if in January 2020 an employee had an FTE employee had terminated? That would be January 15th they were terminated. Are they still deemed an FTE for the first 2 months, or some fraction of that?
So the statute itself only says use the average, quote, average number of full-time equivalent employees per month during the covered period. So it's a little bit vague. I think the regulations, which are supposed to come out within 30 days, hopefully will clarify this. But until then, my advice would be to use a kind of a common sense determination. So if you have a half-time employee or an employee that worked part-time for half a month, I would count them as a 0.25 towards the FTE for that month.
All right, Debbie, is the government boost of $600 on unemployment for the full allowable time under the state? For example, if the state is now 39 weeks, does the government stipend also go for the full 39 weeks?
Currently, the Act provides that for the expanded benefits, those are available through July 31st of this year.
Thank you. Let's see. Sorry, you guys are answering questions faster than I can read them. Sarah, what time frame is used for payroll costs on loan applications? Is it the prior 12 months or calendar year 2019?
It should be the 12 months prior to the date of the loan application. That is the exact wording of the statute. So I know that the SBA application that's currently out, and some bankers might be saying use 2019, but the statute says use the 12 months prior to the application date. So that would include probably some of 2020 and 2019. And this goes to my point again that, you know, I really think in applying for and getting the maximum loan amount, it's not enough to purely rely on the bankers, because they're just going to try to burn and churn these as much as possible. But the statute says use the 12 months prior to the date of application.
Right. Sorry, the next question was for telehealth. If telehealth services, can they be waived for any telehealth visit, or is it just related to COVID-19? It is permitted right now to waive cost sharing for telehealth for any type of visit unrelated to COVID-19 or related to COVID-19 without disqualifying the high deductible health plan. Next question is, Dominic, could you talk a little bit about the income inclusion being taken over 3 years?
Instead of, this is going to be something on an individual's tax return. And so they're going to be able, essentially an individual, the default will be, with respect to an individual, that when they receive a distribution that's been coded as a coronavirus-related distribution, or they otherwise claim that a distribution was one of those distributions, and it could be either way, that the default would be that they take the amount into income over 3 years unless the participant chooses to accelerate it. So I think just to put a finer point on it, I don't think there's an employer or a plan reporting obligation related to that 3 years. I think it falls on the employee participant in their tax reporting individually.
Thanks. Well, that brings us to 1:15. If you have additional questions that we didn't answer or questions after today's webinar, please email or call your regular Thompson Hine lawyer, who will direct you to a member of our COVID-19 task force. If you're not a current Thompson Hine client, please contact one of us and we can discuss with you options to address your needs. If you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. We issue regular updates on a variety of topics, including the coronavirus. Thank you all for your interest in attending today's webinar. Enjoy the rest of your day and stay well.